Hello, I'm Ian Gascoigne. Today's webinar is Drafting Settlement Agreements, the Thorny Issues. And of course, this crops up in many dispute lawyers' lives with some frequency. So congratulations, you've settled a claim. Now comes the hard part. And it is the hard part because there are four things you need to achieve when you are drafting the settlement agreement. The first is to record the agreement accurately. The second is to make sure the arrangements are workable. The third is to make sure that the agreement you enter into is binding. And finally, and probably the most important for clients, that it doesn't give rise to further disputes as to what it means or how it should be performed. So keep those issues in mind as I now describe the topics of this webinar. There are quite a few of these. I will be dealing with them in differential amounts of time because some are more important than others. It will take longer to explain, etc. The first is subject to contract. That's a familiar phrase. I'll be spending not too much time on that, but highlighting a recent case. I'll then discuss the format of a settlement agreement, which should be quite familiar ground. I'll then spend a bit of time and illustrate ambiguity in the settlement terms. And then the very important section is about the releases, and those are dealt with in two parts, releases generally, and also in dealing with alleged fraud claims. I'll be mentioning a particular case in the Court of Appeal in 2024 called NatWest Bank and Riley. Next topic is protecting non-parties to the dispute, which is often done in practice with multi-party disputes. Penultimately, I'll be looking at agreements not to sue and asking whether they're belt and braces or whether they perform a particular role. And finally, I will be mentioning some boilerplate provisions in the settlement agreement, which again should be familiar territory, and I won't spend long on them. So that's my agenda. I now deal with the first subject, which is subject to contract protection. So we all know as lawyers, if you are negotiating an agreement which you want to be put into a final form, the parties usually agree that their discussions are subject to contract, which means that any arrangement or agreement they come to in the course of their negotiations is not binding because the parties have stipulated that there must be a written agreement executed by the parties to it to give effect to their negotiations. In other words, arrangements made during the negotiations don't bind the parties unless and until a written agreement is put in place. Now, not all settlement agreements will have this requirement. If you're settling a case which is quite straightforward and you want to do so very quickly, often you don't worry about the subject of contract, you just negotiate and reach a deal in the course of the negotiation. I'm thinking about a bit more complicated situation where the parties will be exchanging drafts of their agreement and making amendments to it. Even more difficult is if there are more than two parties involved in that process.